Good afternoon, honourable members, and welcome to this meeting of the Standing Committee. Good afternoon, Honourable Marais. I'll give you an opportunity to introduce yourself just now. Welcome to everybody that has joined us at the Standing Committee on Agriculture, Environmental Affairs and Development Planning meeting. Today is Wednesday, the 24th of March, 2021, and we are meeting by and large to consider the draft negotiating mandate report on the upgrading of the Land Tenure Rights Amendment Bill, also known as the Ultra Bill. Before we start with the agenda, I would just like to indicate I've received no apologies, and therefore, members, if I could ask that we introduce ourselves, starting perhaps more or less in alphabetical order with Honourable Bartman, and if the rest could follow just introducing themselves. Thank you so much.
Thank you. Good afternoon, everyone. Deirdre Bartman, member of the committee.
Good afternoon, everyone. Pat Merrin, member of this committee.
Good afternoon, Chairperson Matlodi Maseko, member of this committee.
And Honorable Murray.
Good afternoon, members. Peter Murray, Freedom Front Plus.
Thank you, honorable members. And again, I appreciate you joining us at this meeting. And a special word of welcome again to Honorable Murray. I'm glad you're in a position to join us again. Honorable members, as you know, we have been asked by the NCOP to consider this bill, Bill B6B of 2020, which has been tagged as a Section 76 bill, the Upgrading of Land Tenure Rights Amendment Bill. And we've been put under a lot of pressure because the court determined that these amendments to bring the original act in line with the Constitution needs to be finalized by the 30th of April of this year, which left us with very little time. We, as is custom and in line with the Constitution, went out with a public call for comments or inputs on the bill, and the closing date for that was the day before last, that is Monday the 22nd of March. And I'm just quickly going to give our procedural officer, Ms. Shireen Niekerk, an opportunity just to share with us the inputs that were received from the public and from other institutions. So, Ms. Niekerk, if I could just ask you to please just share with us. I can just indicate to members that the inputs that we've received were also circulated to you via email. Ms. Niekerk.
Thank you, Chairperson, and good afternoon to you and all our members and guests. The committee did not receive many comments on the amendment bill, and the committee did not receive any comments from members of the public. The three responses received, the first response was from the Department of Economic Development and Tourism, whose response was submitted through the Department of the Premier. And the response was basically that the Department of Economic Development and Tourism will not be commenting on the amendment bill. The second response received was from the Department of Human Settlements. It was a memo that was sent to the Department of the Premier Legal Services, stating that the Department of Human Settlements submitted comments on the amendment bill in June last year, and that they are submitting no comments in response to this committee's call for input. And in summary, the comments submitted in 2020 that the Department of Human Settlements referred to basically stated that it does not have any competencies in terms of the amendment bill, and further stated that the Department of Human Settlements is unclear to which extent the Western Cape government would be responsible for implementing the Alter Bill. The third input received was from the Department of Agriculture, and the department provided a list of comments and a covering letter to this committee. The covering letter stated that the Western Cape government is unable to support the amendment bill in its current form, and in summary, the reason cited amongst others for this was that the amendment bill was not published for public comment by the department prior to being introduced into Parliament, and that the department did not consult widely on the amendment bill. The Department of Agriculture also stated that the amendment bill is likely to affect the functions of local government, and that in terms of Section 154 of the Constitution, it is required to be published for public comment prior to introduction into Parliament. And for this reason, the Department of Agriculture raised concern that there is a serious risk that the amendment bill may be found to be unconstitutional for procedural reasons in the event that the bill is challenged. So that in essence, Chairperson, is a summary of the comments received on the Ultra Bill. Thank you.
Thank you very much, Mr. Niekerk. Honourable members, there you have it. And we are now at the stage where we must formulate a mandate for our representatives at the National Council of Provinces. Now, this mandate can take different formats. The first one is obviously to mandate our representatives to support the bill, to reject the bill, or also to support certain sections in the bill and then to reject other sections in the bill. And to that extent, honourable members, I would now like to give an opportunity to you as members to take a position, to state your convictions in terms of what you believe we should be mandating our representatives with. I see Honourable Marais' microphone is on. Honourable Marais, if you could just mute yourself for the time being. And I recognize the hands of Honourable Maseko as well as that of Honourable Bartman. Thank you.
Thank you very much, Chairperson. Chair, I mean, immediately when we have an issue of procedural about a bill, something didn't get done correctly, it's a red flag automatically that we cannot even agree to that bill. But I just want to say that the amendment bill may fall foul of section 154 of 2 of the Constitution, as it was not sufficiently advertised for public comment before being introduced to the Parliament. So that was flawed from the onset. That bill was flawed from the onset. And the memorandum on the objects of the bill states clearly, and I quote, the department has not consulted widely on the bill. Now, being said, we don't want to end up with a cost of we waste money trying to push a bill when we know even if any stakeholder can take us to court, is going to really, the court will rule against us. There is therefore a serious risk should the amendment bill be taken on review, that the process followed thus far, at least in respect of public involvement, may be found to be constitutionally unsound. Secondly, the amendment bill only addresses the sections in the Upgrading of Land Tenure Rights Act 1991, which is the Act 112 of 1991, found to be unconstitutional by the Constitutional Court, whereas the committee believes that the Act as a whole should have been repealed and replaced by legislation that will truly secure rights and tenure, also on property that is currently under tribal authority or customary rights. Third, only a small number of aggrieved persons would be in a position to apply to court for appropriate relief, which is unfair. The committee would have preferred the establishment of more accessible alternative measures to address the plight of aggrieved persons. The committee also notes with concern the haste by Parliament to comply with the date set by the court, which in turn has placed the NCOP and provinces under severe pressure to deal with this amendment bill. In this regard, we note in particular that the first 18 months and thereafter an additional 12 months as determined by court were not managed effectively and efficiently by Parliament. So I suggest, Chair, that we reject this bill and that it will be the mandate that we have to send to the NCOP. I thank you, Chair.
Thank you, Honourable Maseko. Honourable Bartman and thereafter Honourable Maran.
Thank you, Chairperson. No, I support, Member Maseko has covered what I wanted to indicate, and I support that input towards the negotiating mandate, and I also support the request or the motion to reject the bill. Thank you.
Thank you, Honourable Maran.
Thanks, Chair. Chair, thanks very much, Chair. Look, Chair, just from my side, basically all the issues now raised and the reasons why we should not support the bill was not previously raised. The issues that came up now. And I think, Chair, the Constitutional Court were very specific when he pointed out which sections of the bill basically is unconstitutional and should be looked at. And that's basically what we have dealt with in the, I think, the select committee meeting. So, Chair, based on that, Chair, my view, and if it becomes a minority view, is to support the amendment bill in its current form. Chair, thanks.
Good. Honourable Moran, thank you very much. I recognize Honourable Maseko's hand again.
Sorry, Chair, is this old hand? I don't know what's wrong with it. I will drop it.
Good, thank you. And can I ask that Honourable Moran then also lower his hand? Honourable Murray, I just saw quickly that you wanted to switch on your microphone. You're welcome.
Thank you.
You have the floor.
Thank you, Chair. I want to just say that we got to be very careful that the courts don't become pseudo legislators. You know, power is a strange thing. And even the courts can sometimes tend to abuse their powers. So I want to say that we got to look at this, and our legal guys and constitutional people had to give us a far better input in this regard. To what extent is what is written in the law a function of legislation and their will, because the only people who got the mandate to make laws are those in the legislature. We consulted the people voted for us. We have the right to make laws within the ambit of the Constitution. So when the Constitutional Court or any high court rules against us, we must just make absolutely sure this is not interfering in the powers given to legislators to make laws within that Constitution, and it doesn't deviate from that, because I'm getting quite concerned how many times people or NGOs run to the High Court to try and usurp the powers of the legislature. I'm very concerned about this is happening too frequently.
Thank you, Honourable Murray. I don't want to come down too quickly on to Advocate Marstorp, but I think, as you quite rightly said, Honourable Murray, if legislation is found not to be in line with the Constitution, then the court can obviously refer or suspend such legislation and say, please first bring that in line with the Constitution. And perhaps, Advocate Marstorp, if you wouldn't mind just perhaps explaining to the committee why this legislation, which I think I also need to point out, Honourable Murray, dates from before the days when the current Constitution of South Africa was adopted, why it was found to be unconstitutional. On what grounds was it found to be discriminating unfairly? Advocate Marstorp, would you be able to assist, or am I a bit too quick?
Afternoon, Chairperson. Chairperson,
Good afternoon. We hear you well, and thank you very much for joining us and for coming to our assistance as well.
Certainly, Chair. Chairperson, I noticed that some of the members referred to the memorandum on the objects of the bill, and that memorandum in its earlier paragraphs give sort of an indication for the background to this bill. As the Chairperson correctly indicated and observed, the Upgrading of Land Tenure Act predates our Constitution, and the legislation that predates the Constitution are still on the statute books. And only at that time, when an aggrieved party, an interested party, or someone with some or other stake in respect of the substance of a particular law, only when that person feels that the law that predates the Constitution appear in its terms to discriminate against him or her, only then will that person then seek redress in the court. So for years still, it seems, we will have instances where pre-constitution laws will be challenged in order to bring those laws in line with the terms, the spirit, and the reach of our Constitution. In fact, I as a lawyer, I as a citizen, I as a South African would have it no other way. If civil society, be it an NGO, be it a private person, challenges laws and in an attempt to ensure that those laws are aligned to the Constitution. That being said, so in other words, I'm saying that for some years still, we will have instances where civil society challenge laws, even post-1996 laws, which may not sufficiently speak to our changing, evolving social norms, will be challenged. And that is beautiful because it is dynamic, it is fluid, and it speaks of a progressive, growing, transforming society. So I have no qualms that we are faced frequently with instances where laws are being chiseled, are being nudged and squeezed to bring it in line with the provisions, with the effect, and with the spirit of the Constitution. I can assure you, Chairperson, that the doctrine of separation of powers is very much well established, is very much well vested in our constitutional structure. And there is hardly a way, with the respect one has for our judiciary, that the judiciary will usurp the role, the powers, the authority, and the mandate of Parliament or provincial legislatures. There's hardly an instance of that. We are too sensitive, we are too vigilant, and we have too a diligent judiciary for that to potentially happen. So there's no qualms when we are challenged as lawmakers to bring laws in line with the Constitution. There's no qualms. That's a sign of a fluid and dynamic civil society. What is of concern here is that, again, a pre-1996 law, in other words, a 1991 law, was deemed to be unconstitutional in respect of certain and very limited ways. And that was in respect of those two court cases, which serve as a basis for this bill. Only in respect of those two court cases, and rather only in respect of those two provisions when it comes to automatic conversion as well as the application of certain provisions throughout the country. We do know that the old Act only has limited application throughout South Africa, and that is because that was the reality, the political and social reality in 1991. Now that we have the court cases, we needed that alignment, that nudging, that chiseling of our laws to be in line with the Constitution. What this bill seeks to do, and this bill only seeks to do that, is to respond to the directive, if you like, the judgment of the Constitutional Court in respect of those two issues, automatic conversion as well as the application of certain sections throughout the country. Now, I am not a procedural advisor. Let me say the following. Having read the bill, having read the memo on the objects of the bill, it appears that in substance, on the merits of the provisions, it addresses the concern that the Constitutional Court raised. Substantively, it appears to address that concern. However, this bill seems to successfully trip over its own feet because of the compromised timelines that was thrown in the direction of the NCOP and in turn of us as legislatures. On its substance, it appears that the bill meets the objective set by the judgment of the Constitutional Court, but then the bill trips itself up by compromising procedure, and I agree, inasmuch as I'm not a procedural advisor, that on its own may expose our legislature to a constitutional challenge should it support this bill, given the timelines, given the admission by Parliament itself of limited public engagement. I am not expected to give opinions in that regard, but certainly the timelines that have evolved, that have lapsed since the judgment, are inexcusable. That we are now sitting with a situation where our legislature, our standing committee, is squeezed to yield a mandate, whereas those out there who may have an interest in the substance of this bill were not sufficiently thoroughly engaged as the Constitution demands. So, just in final, Chairperson, unless there's further questions, it appears on the substance that the bill speaks to the judgment and the caveats that were raised by the judgment, but procedurally, in terms of the process having been followed or not having been followed, I am not at liberty to advise to support this bill. Thank you, Chairperson.
Thank you very much, Advocate Marstorp. Honourable Murray, can I just add, my impression was also that the bill referred to the head of a household, and then in regulations this was defined as a male person, and that this is also one of the problems that were experienced in that we now often have households headed by women, and that the concept of a household only being able to be headed by a male person is also unconstitutional. But I see your hand is raised, and
Chair, I'm just very skeptical about a few things, and when I do speak, I make no bones about it. I fight for the colored community. And I want to say, how will this bill affect Elim, Genadendal, Wuppertal, all those areas? Who's the head of the house there? Are we opening up a loophole that that land can somehow be negatively affected in terms of succession, the law of succession? I don't know if the department has really gone into it. Just, we must remember, there's individual rights, but there's also communal rights. There's also traditions. There's also cultures. We mustn't leave an opening for the legal brains in this country to sort of interfere with cultural issues. There are some cultures where the head of the house is a man. And I don't know whether we are prepared to take on the Zulu kingdom. I saw the president has gone there and bowed before him when he was really upset by something they wanted to do about his land. Okay, so we don't have a colored king that can get the president to run to Mitchell's Plain and explain. So I'm here to defend that. How will this affect communal land? not only in black areas, but in colored areas. In view of the Trankra Act, which will be implemented hopefully soon, did we just stay ourselves blind as to this case, this one case? And I wanted to agree with the DA on this issue that we could say, no, look, man, administrative law is just as powerful as any other law, criminal law, whatever. And purely on the basis of administrative law, they can't just chop and change how many times they give us for public participation or let the public give their input. So I feel a bit uneasy about the whole issue. I feel really uneasy.
Good. Thank you very much, Honorable Marais. And then over to Honorable Maran.
Thanks, Chair. Look, Chair, I've carefully listened to Mr.
Advocate Marsdorp.
Romeo. Basically, what these the Constitutional Court judgment basically tried to achieve, and what he basically says is that the Constitutional Court judgment was specific. It refers to certain sections of the Ultra Bill which is unconstitutional. Now, and the issue is that your deeds of grant was basically in the name of the head of the house, which is the male person, and then it was automatically turned into ownership, meaning the male person has become the owner of that house. Now, and that in itself basically was problematic. It discriminates against women, and it's for that reason why this matter was taken to the Constitutional Court. Now, Mr. Marsdorp says that the provisions and those that should be changed, he don't have a problem with that. And in fact, he agrees with the Constitutional Court. Problem is the timeline. That's the main problem and the reason basically why some say we can't support. But now we hear other arguments about certain legislation that will be affected, households, whether it's a man or a woman, how will it affect people from Renadenal and so forth. And the previous speaker, not the previous one, I think the Honorable Maseko, raised the issue of municipalities or local government spheres will also be affected. Point here, Chair, there's a Constitutional Court ruling saying that those sections are unconstitutional. Therefore, we have no choice but to go to the bill and correct it. I hear the concern in terms of the time frames. If it's legit, that should be the only concern. But we have no choice but to say we have to agree with the Constitutional Court, and therefore we have to go and look at the Ultra Bill and make those changes. And I think that's basically what Mr. Marsdorp tries to say. He also, in closure, said that he have no, is it the word obligation that he've used, to advise to support or not to support. I understand that. But in his explanation, he made it very clear that in terms of the changes as proposed by the Constitutional Court, there is no issue with that. Absolutely nothing wrong. The issue is just the issue of the time frame. Thanks.
Thank you. Can I just ask that those that raised their hands before lower it, and then I recognize Honorable Bartman.
Thank you, Chair. Chair, just two small things. In terms of procedure, sometimes I think we don't necessarily consider procedure as important as it is. When it comes to the Lamosa judgment of the court previously, I think that the court has made very clear the importance of procedure, which includes things like public participation, for example. That's the first part. Regarding the substantive matters of the bill as raised by Member Maseko, and which I supported, Chair, if if the NCOP or the NA in the bill has not raised particular substantive matters, it doesn't mean that we as a province cannot, in terms of this committee, cannot raise substantive matters on this platform, in this committee, as part of the negotiating mandate. When one does a briefing, you get the briefing obviously because you're trying to get the context, you're trying to get extra information from the respective departments. When you do the public participation, you're trying to obviously to gauge how does the public feel, and with the information one gets or does not get sometimes, and with the briefing, with the information, and with all of those documentation that we get from the NA and the NCOP, as including things like the documents regarding public participation, we are as a committee also obligated to make up our own mind, which was also a statement made by the court in the Lamosa judgment, where that particular act, that particular land act, was sent back to Parliament, because it said not only is the NCOP obligated in terms of the Constitution to do certain things, but every legislature is also obligated in terms of the Constitution to do certain things. And because of that, because the Western Cape Provincial Legislature or Parliament is separate to the NCOP, and because its impacts upon the provinces, it is also our duty to also as a committee now make up our mind on how we feel about the bill. So I do believe that such substantive matters can be raised and noted and minuted as part of a negotiating mandate, as well as that we just need to be...
In terms of our mandate and the rules of engagement with the NCOP, those rules do not provide for a minority view to be included within the mandate. But we can certainly record, and we will certainly record your views in terms of the committee's minutes that we have for today, etc. I want to give over to Ms. Niekerk. I don't know how good her shorthand is, because Honorable Maseko went quite quickly through her proposed resolution. And Ms. Niekerk, perhaps if you could just say to us or indicate to us whether you've been able to capture everything that Honorable Maseko has said, and if you could just perhaps also confirm whether my understanding of the rules of engagement is correct. Over to you, Ms. Niekerk.
Thank you, Chairperson. In terms of the rules of engagement, a minority view is allowed to be expressed in the committee's report, but not in the negotiating mandate itself, because the negotiating mandate is a schedule prescribed in terms of the Mandating Procedures of Provinces Act. So certainly Member Moran's minority view can definitely be captured in the committee's report. Chairperson, just in terms of the capturing of what was now agreed to in the meeting, I respectfully just request that you just suspend proceedings for about 10 minutes. Just allow me to compile that report. Please, if you don't mind, if members don't mind, I'll appreciate that. Thank you.
Good. Ms. Niekerk, I think Honourable Murray sought some clarity on whether this upgrade of land tenure rights amendment bill also apply to certain of our communities in the Western Cape that are not what in some terms are used referred to as tribal land. So perhaps, I don't know if Advocate Marstorp would be ready to just inform Honourable Murray in this regard while Ms. Niekerk is just compiling the report. Advocate Marstorp, I think you heard the questions from Honourable Murray. Would you please be so kind, if possible, just to give an indication as to the applicability of this bill, or I presume it might actually refer to not the bill but the original act, just to inform us and you know, give some clarity to us as members dealing with this legislation.
Thank you, Chairperson. Chairperson, I heard Member Maria's question. This bill does not deal with that issue. In other words, the question as it was put is irrelevant to the amendment bill's provision and what it seeks to achieve. It seems that the question would have been perfectly relevant if we were dealing with the primary act pertaining to the upgrade of land tenure. For now, with proceedings before this committee on the 24th of March, the question is irrelevant to these proceedings. Having said that, I do recall during the briefing by the department, I do recall also having read in the memorandum of this bill that the department is very much invested in an exercise to review all legislation pertaining to land and land tenure. So from what I can anticipate, we may in due course be faced with another slew of bills, or a bill that will then be a consolidation of everything dealing with land and land tenure. I would want to suggest then that Member Murray just suspends his question in anticipation of that process. For now, we are faced with a question to endorse or give a mandate to a bill that just deals with two issues. The other substantive issues dealing with land and land tenure are still provided for in the Principal Act. And if it is that Member Murray or any individual in South Africa, in this province, is of the view that that Principal Act does not in its terms speak to all communities, that it is latently or impliedly discriminating against certain groups or minority groups in the province or in the country, then that person, that group of persons, that NGO can certainly jog back to the Constitutional Court, which may then cause us to be faced with another bill which will deal with that particular issue. The Principal Act is always there to be challenged. And I think Member Murray's question may just be one of those that will challenge a provision in the Principal Act. Someone else has jumped the queue as far as Member Murray's question is concerned and went to the Constitutional Court regarding automatic conversion and regarding the application of the Primary Act throughout the country. That person caused the Constitutional Court to come up with a judgment, as a result of which we are now sitting with a bill regarding that issue. In due course, if someone else challenges that Principal Act regarding an issue pertaining to minorities in certain regions, then we will be faced with a bill on that issue. And gradually, incrementally, maturely and responsibly, we will chisel all our legislation in line with the Constitution. Thank you, Chair.
Thank you, Advocate Marsdorp. And I trust that Honourable Murray's questions have been responded to. Honourable Murray, please remember now we are discussing the mandate on the bill. I wouldn't like us to dwell too widely off the agenda for today. But on the other hand, I do appreciate that this is an opportunity for ourselves to familiarize us with the legal context. So over to you, Honourable Murray.
irrelevant
Thank you,
questions.
Advocate Marsdorp, and thank you, Chairman, for giving me another opportunity. I'll be brief. You know, I know that the Principal Act might not be the issue here, but they say little grains of sand make the mighty shore. You get one little act here, another little act there, both pass legal scrutiny, and then you come up and you load that act and attach an addendum to it, and then you get what you want. So ek sien die kooi saan agter die bos wegkruip om die bokkie te vang. Now, I am just asking, I asked the questions. If the legal fraternity says it's fine, I say yes, but I am not so sure that this is not a precursor to something much bigger than this, and it can have a lot of ramifications for land ownership. And I also don't know how, I will leave that to the Nguni tribes, where the chief has 5 or 6 wives. Which wife gets it? We'll again go to court and say which wife should have got that share and which shouldn't. But leave that as it may. I'm not happy with the procedural aspect of how this has been handled, and for that I stick to my decision to register anti-vote on this issue.
Thank you, Honourable Marais. Ms. Niekerk, is this debate given you enough time to draft the report for us, or do you still need us to adjourn for a few minutes?
Chairperson, thank you very much. If we could just adjourn for 5 minutes, it would be appreciated. Thank you.
Thank you, honourable members. I will then suspend proceedings for 5 minutes. It's 13:45 now. If we could meet at 13:50, I'll appreciate that. Sorry, Mr. Marsdorp, Advocate Marsdorp, before we suspend, would you like to respond?
Certainly, Chair, thanks for the opportunity. I just want to maybe alert the chairperson that I am due to attend another committee meeting at 2 o'clock. So either I can be excused now in anticipation of no further questions, or I just alert the chair that at 2 o'clock I will be obliged to leave this meeting. Thank you, Chair.
No, thank you very much. So, honourable members, 5-minute suspension, and please stay online so that we don't have trouble rejoining. It's just to give Ms. Niekerk an opportunity to be able to beam up the draft mandate onto our screens.
Deirdre, can you help Honorable Mare with his hand? It's stuck.
You must lower the hand function, member.
Thank you, members. This is the chairperson, Andrikus van der Westhuizen. We have had our suspension of 5 minutes, and I can see that our procedural officer has been able to beam onto the screen the proposal as put to this committee by Honorable Maseko. Honorable members, please, if you could read carefully through what you see in front of us. I don't know, will you give Ms. Nikak an indication when she can scroll down? Just a few seconds for you to read. Thank you, Ms. Nikak. You can scroll down. Advocate Marstorp, I recognize your hand.
Thank you, Chairperson. Chairperson, I'm not sure how long the mandate is. Just for purposes of record, I would maybe suggest that Ms. Nikak read the mandate into the record so that everyone is familiarized and it is there for future reference. It's a suggestion, Chair.
Yes, no, thank you very much. I think that is perfect. And thank you for reminding us, because I think quite often people will only be listening to the recordings. We are still in the process of migrating to the YouTube versions where people will also be able to see what was in front of the committee. So perhaps, Ms. Nikak, if you want to scroll up again, I'm going to quickly read into the record then this negotiating mandate. So at this draft negotiating mandate stage, report of the Standing Committee on Agriculture, Environmental Affairs and Development Planning on the upgrading of Land Tenure Rights Amendment Bill B6B 2020 NCOP dated the 23rd of March 2021 as follows. The Standing Committee on Agriculture, Environmental Affairs and Development Planning having considered the substitutional court, whereas the committee believes that the Act as a whole should have been repealed and replaced by legislation that will truly secure rights and tenure also on property that is currently under tribal authority or customary rights. Only a small number of aggrieved persons would be in a position to apply, and I'm quoting, to court for appropriate relief, end quote. The committee would have preferred the establishment of more accessible alternative measures to address the plight of aggrieved persons. The committee also notes with concern the haste by Parliament to comply with the date set by the court, which in turn has placed the NCOP and provinces under severe pressure to deal with this amendment bill. In this regard, we note in particular that the first 18 months and thereafter an additional 12 months, as determined by the court, were not managed effectively and efficiently by Parliament. In accordance with Standing Rule 90, the African National Congress expressed its minority view that it supports the amendment bill in its current form. Honourable members, that is the draft report. That is what Honourable Maseko proposed, and it was then supported by Honourable Bartman with the amendment in adding the last sentence by Honourable Maran. Can I just get an indication of whether you believe this report to be an accurate reflection of our decisions this far? Honourable Maran, you're first.
Chair, Chair, I just want to check one thing because Mr. Marsdorp asked for the negotiating mandate to be read into the record, and I think that's exactly what you have done now. I just wanted to check, Chair, whether you have read the wrong date into the record. Because if I'm not mistaken, the date of the 23rd was up there, 23rd March 2021, and I think it was changed afterwards. Just on the issue of reading it into the records, whether it will be a big issue or not, I'm just asking.
Chairperson.
Please proceed, Ms. Niekerk.
No, I just unmuted my mic just to alert you to that. I had the incorrect date at the top of the report, and I just changed that to today's date, the 24th of March. Initially, I had the 23rd of March. Member Maran is correct, yes.
Yes, thank you very much. And thank you, Honorable Maran, for helping us to correct that. Honorable members, that is the report in front of us. Am I correct in saying that there's majority support for this mandate in its current form? Honorable Bartman?
Thank you, Chair. I propose that we move to adopt the report.
Any votes against that? Anybody believing that this is not the decision by the majority of this committee?
I seconded for the report to be adopted. The report, Chair, reflects basically the discussion and the decisions taken. And also it reflects the minority view of us as the ANC. Thanks.
Thank you. Thank you, Honorable Bartman. Thank you, Honorable Maran. The report is therefore duly adopted. Honorable members, thank you very much. We still have a number of minutes as well as the report on our oversight visit to Klein Eseljacht Farm to consider. Advocate Marstorp, thank you very much for your support as well. You are excused to jump over and join the meeting starting at 2 o'clock. And
Thank you, Chair.
we really appreciate your input. It was most valuable and we really appreciate that. Thank you.
Thank you. Thank you, Chair.
Thank you. Honourable members, our ever-efficient procedural officer has beamed onto your screens the minutes of our meeting of the 19th of February 2020 with the Department of Environmental Affairs and Development Planning.
2021, Chairperson, apologies.
2021, thank you very much. I'm glad to see some people have got real good eyesight. So, honourable members, that's page 1. Can I then ask that we also go over to page 2? Thank you. I also then want to ask you, honourable members, whether we can adopt these minutes. Honourable Maseko. Honourable Maseko, you can unmute yourself.
Sorry, Chair. I'm saying that I move that to be adopted, and I promise you I eat the carrots. My eyesight is still well. You'll be proud of me, Chair. Thank you very much.
Thank you. Honourable Bartman.
Thank you, Chair. I second.
Thank you very much. Duly adopted. Then, Ms. Niekerk, can we also consider the minutes of the 25th of February? Thank you very much, honourable members. You see it there on your screens. The date is the 25th of February 2021. Thank you. Page 2 we've got in front of us. That was the meeting on the trophy hunting of leopard. Thank you, honourable members. Can I have an indication of whether you support the adoption of these minutes? Thank you, Honourable Bartman, and then Maseko.
I move to adopt, Chair.
Honourable Maseko.
I second the move, Chair, to adopt.
Thank you very much. Duly adopted. We then jump a month to the 19th of March. That was last week and Friday afternoon when we were considering the vote on agriculture. Thank you, Ms. Niekerk. Honourable Marais' apology was duly noted. Yeah, it is there. I put to you page 1, then page 2, Honorable Bartman.
Thank you, Chair. I move to adopt.
Thank you. Is there support for that? Any other views? Honorable Maseko?
Chair, I second the move to adopt.
Good, thank you very much. Duly adopted. We now go to the minutes of yesterday's meeting. Again, on the budget. This was on both the third adjustment budget as well as the appropriation budget for this upcoming year. And now Honorable Maran is not able to indicate support or not, as his apology was duly noted. I put to you page 1, and then page 2. Thank you, Ms. Nikak. You did minute that in the absence of Honorable Maran, Honorable Smith later joined this meeting.
I noted that at the top, Chairperson, as an alternate member, you will see it right there.
Good, thank you very much. So, honorable members, can I have a proposal to adopt these minutes? Honorable Maseko?
Thank you, Chair. I move that we adopt the minutes.
Thank you. Honorable Bartman?
Thank you, Chair. I move to second.
Thank you very much. Honorable members, are there any that deals with the third item on our agenda, which brings us to the last and the fourth item? Should members wish to propose resolutions or actions for this committee, you are welcome to do so now.
Chair, I ask to be excused. I must rush now to get to another meeting of the Cultural Committee. If members will please excuse me.
Thank you, Honorable Marais, and thank you for your active participation in this meeting, and best of luck with the meeting following on this. We appreciate that you made time and that you are jumping between these meetings.
Thank you, sir.
Thank you for your input. You are excused.
Thank you.
Good. Thank you, honorable members. I forgot to also present to you the oversight visit to Klein Eseljacht, and thank you very much for Ms. Nikak for putting that onto our screens before we get to the resolution phase. Honorable Maran was there, Honorable Maseko was there, and Honorable Bartman and myself. So page 1 of that report. Then page 2. Thank you, honorable members. Perhaps you could just pause a little bit at the resolutions. We promised that we will engage the Department of Agriculture regarding an update on the request made by Mr. Kluter to purchase the farm. And 4.2, that in order to assist fruit farmers in the Genadendal area to schedule farming activities such as irrigation outside of load shedding times, the Department of Agriculture engaged with Eskom in the Western Cape, requesting Eskom to avoid load shedding during critical times for the collective fruit farming industry. I believe that is what was said there at the meeting or during the oversight visit. Good. Honorable Maran, I don't see your hand, but I do see that your microphone is on. And then Honorable Bartman, your hand.
Yeah, Chair, because the other two are too fast with their hands. Therefore, I've decided just to unmute me. It's a sign. Now, Chair, I want to propose that that was the resolution that we have taken, and basically to accept or to adopt the report.
Thank you very much. Over to you, Honourable Bartman.
Thank you, Chair. Chair, I second Member Moran's moving to adopt the report.
Good, thank you very much. The report is then duly adopted, and that then again brings us to the point which unfortunately I jumped to too early, and that is the point: resolutions or actions. Honourable members, are there any resolutions that you would like to propose flowing from today's meeting or other aspects that might affect this committee? I see no hands. Therefore, I want to say thank you very much, honourable members. Again, thank you to Ms. Niekerk, who really had to, over the last few days, work very hard since the closing of the due date for public comment, and then also to help us to successfully draft this mandate to our representatives in the National Council of Provinces. Honourable members, in our decision or mandate today, we refer to the undue pressure that's been put on this committee, and unfortunately it means that we will have to meet regarding the final mandate during the leave/constituency period that is coming up in April. And if I'm correct, I think the time set aside for that meeting is on the 7th of April at 1 o'clock. Perhaps Ms. Niekerk can just confirm whether I'm correct.
That is correct, Chairperson, yes. 7th of April at 1 o'clock.
Good. And the 7th of April, honourable members, that is a Wednesday, just after the Easter weekend. So I do hope that you would be able to join us for us to then finalise our position on this bill. So with that, honourable members, thank you very much for joining us. Thank you very much for your input. Thank you very much for the spirit in which we have been able to deal with these meetings. And this meeting is therefore now adjourned. We see each other again on the 7th of April. Thank you.